Hey everybody, I'm attorney Jason McGrath with McGrath and Spielberger. I practice in North Carolina primarily, but also Florida and Tennessee, and my law firm practices in these other states you can see over my shoulder here. We're going to talk about summary judgment and also deficiency judgments in North Carolina, post-foreclosure deficiency judgments. A recent case, legal opinion came out just a few weeks ago here in North Carolina that basically said if you are a foreclosing party who has foreclosed and are now suing in an independent collection action, which is how it's done here in North Carolina typically, for like a typical residential foreclosure and many commercial building foreclosures, commercial property foreclosures, then you are going to perhaps go to trial, even if the only quote-unquote fact in dispute is the value of the property that was seized and sold at foreclosure sale. So by way of hypothetical example, let's just say that you've got a residential property that's worth $300,000, supposedly, okay? But the foreclosure sale only nets $250,000. And let's just say that the foreclosing party is the highest bidder. So Wells Fargo forecloses, and they're owed $300,000, and they sell it at foreclosure sale to themselves for $250,000. And then within the next year, Wells Fargo files a follow-up separate legal proceeding, legal action to collect money from the borrowers, the former homeowners, because they say, hey, look, you owed us $300,000, we foreclosed, we sold the property at foreclosure sale, and we only got $250,000 back. And depending on what the actual sale price was, of course, they're going to pay lawyer fees and other costs and fees and all this and that. So, but regardless, for this, we'll say that Wells Fargo ended up with $250,000 in their pocket, and they were owed $300,000 on the loan. Well, the borrower, as part of a defense or really a mitigating factor or an offset factor in the lawsuit, would say, look, Judge, Wells Fargo is claiming that I owe them $50,000. But I'm here to tell you that they actually undervalue the property at the foreclosure sale. It was really worth $300,000, and it should have fetched $300,000 at the foreclosure sale. And Wells Fargo basically, had they bid $300,000, the value of the property, then they would have been covered, and they would not be able to recover anything else from me because they would have been made whole. Wells Fargo, might have an appraisal, probably would have an appraisal, and say, well, wait a second, our appraiser said this was only worth $250,000, so that's what we bid, that's what we paid, and you do owe us the remaining $50,000. Well, typically in the past, the borrower would have to typically have an appraisal themselves or some other expert or quasi-expert opinion that says, hey, no, Wells Fargo's appraiser said it was $250,000 as far as value, but the county said it was $300,000, or my appraiser said it was $300,000. But in this recent opinion, the court actually said that the owner, the former owner, the borrower, may be able to simply testify on their own to the value without bringing any other witness in. And that alone might be enough to defeat summary judgment, meaning that the case would typically have to go all the way to trial if the sides can't resolve it. So that's a potential change in the law, or at least the application of the law here in North Carolina. It's important on the lender side, the foreclosing party side, because it can certainly make it more difficult and more expensive for them to recover monies in a post-foreclosure collections lawsuit, a deficiency judgment lawsuit. And on the borrower side, you have to be aware that you can go ahead and raise this issue and potentially prevent judgment from being entered against you, at least maybe up until trial, because of this dispute over the value of the property. And also it might give lenders an incentive, or the suing party, the creditor, an incentive to settle these cases on terms that are more favorable comparatively to the borrower. So it's important to be educated about the updates in the law and the way the court is applying these laws as time goes on. So good luck out there. We handle these kinds of cases on a regular basis, and if you need to talk to us about your case, go ahead and give us a shout. Thank you.